Please be seated. We'll hear argument in 2507, Fieldturf USA versus Pleasant Grove Independent School District.
May it please the court, Mr. Bennett will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, although Fieldturf endured 3 years of litigation and a 5-day jury trial, it's required now under the Court of Appeals judgment to endure a new trial, but not because the Court of Appeals found any error in that prior trial or because the Court of Appeals disagreed with Fieldturf on any of its 5 rendition points. Indeed, the Court of Appeals in its decision mentioned none of Fieldturf's rendition points. Instead, the Court of Appeals tried to justify the remand in the interests of justice based on the vacatur of an underlying order of a co-defendant granting summary judgment. That interest of justice remand was wrong as a matter of law for several reasons. The first two are reversible error regardless of the propriety of the summary judgment order to the co-defendant, and that is under 43.1 or 43.3 and 47.1, the Court of Appeals was obligated to decide Fieldturf's rendition points, which would have obviated the trial that it's now been ordered to endure. The rest of the points of error concerned the erroneous reversal of the summary judgment order on Altech's behalf, in which Fieldturf and Altech both have an interest because that was the basis for the remand in the first place. Starting first with Rule 43.3, this court's decisions in Bradley and several others make clear that when there are rendition points that would render judgment on the appellant or cross-appellant in this case, the Court of Appeals has an obligation to decide those. In Bradley's, it was a venue order. The Court of Appeals, instead of reaching rendition points in that case, remanded because of a venue error, what it found to be venue error. And this court reversed, stating that the Court of Appeals had an obligation to decide the rendition points in the first instance, which might have obviated the need for any further proceedings. And that should hold sway here. Bradley's applies. Any of Fieldturf's rendition points would have obviated the need for the new trial that we've been ordered to endure again. And we've supplemented our brief with a decision from the 7th Court of Appeals recently on very similar issues. In fact, the first 2 issues in that case, New Braunfels Independent School District v. Fieldturf, identical warranty language, at least for the material part, resulted in the very judgment that we sought from the Texarkana Court of Appeals, and that we weren't given, but without any mention as to why. So on that basis alone, 43.3, the court should reverse the Court of Appeals judgment and remand with instructions to resolve those rendition points. 47.1 provides a corollary but separate rule for reversal, and that's the court's supposed to afford the greatest relief that it can afford, resolve the points that the parties have fully briefed. And the parties fully briefed all of Fieldturf's rendition points. Sloan is the case this court decided. West is another one. In both cases, there were threshold legal issues that the Court of Appeals should have decided and didn't, instead remanded for further proceedings without reaching those threshold legal issues. And in so doing, they committed reversible error.
Do we reach that issue if we decide that the Court of Appeals erred by reversing Altech's summary judgment? Because that was the basis of the remand in the interest of justice. So if that was error, then there couldn't have been any remand in the interest of justice on those issues.
Correct. There are 2 paths for this court to reverse the Court of Appeals judgment as far as Fieldturf is concerned. One is completely severable from the issue of the erroneous vacature of the summary judgment order. But if we move to that, which is the erroneous decision to vacate Altech's summary judgment, that itself was error for several additional reasons. Which is, the first one is the basis for the Court of Appeals judgment was that because Altech hadn't reduced to a written order objections, evidentiary objections that clearly were sustained on the reporter's record, and that's Reporter's Record Volume 4, pages 16 through 32 is an extended colloquy between the trial court and the parties on these evidentiary issues, resulting in the unequivocal declaration from the trial judge, I'm granting the summary judgment and sustaining the objections. There's no dispute that that's the primary, not sole basis for the summary judgment order. And the Court of Appeals' only reason for disturbing that conclusion was an issue that the district didn't raise until its reply brief below. And that is that actually the summary judgment evidence that the trial judge said it was excluding didn't actually get excluded, because Altech didn't also say in the order granting summary judgment, oh, and by the way, I sustained all your evidentiary objections too. That legal conclusion is wrong as a matter of law. The corollary that we draw is Texas Rule of Appellate Procedure 33.1, which is a preservation rule, but it provides sort of an analogous reasoning, which is no written order is required to preserve objections. If it's clearly stated in a reporter's record that you objected and that the judge overruled or sustained, whichever it is, your objections, that's preserved and no separate order is required, whether it's summary judgment, trial, or anything else, an injunction hearing, whatever it may be. We cited a case from the Texarkana Court of Appeals itself where it was a mandamus issue, where an evidentiary issue arose, and the Texarkana Court of Appeals looked to 33.1 and said, well, the same thing applies even on mandamus review. You don't need a written order to preserve.
What is your response to the argument of the school district that Altech's own inclusion of the Kunkel report created a fact issue?
Well, we have a few responses to that. One is that the court shouldn't even reach the merits of the evidentiary issue because of the district's waiver, and it waived in two different ways. And this gets back to the legal error the Court of Appeals committed with turning its eyes from the reporter's record and the clearly sustained objections. If that conclusion is wrong, then the district never attacked, ever, that evidentiary conclusion in its briefing. It laid in wait until its reply to say, oh, by the way, Court of Appeals, that issue, that evidence that the trial court said it excluded isn't actually excluded.
But you're arguing that we should not rely on hyper-technical rules having to do with the lack of a written order with regard to the summary judgment. However, we should rely on these type of technical rules with regard to waiver. And so where's the line between what we should or should not?
I think the line is on what an appellant's burden normally is. And keep in mind, the district is an appellant in this case. It is the primary appellant. We were a cross-appellant, and Altech was the appellee. As the appellant carries the burden for attacking the summary judgment order on all grounds on which it may have been granted. Everyone agrees that the evidence, the exclusion of the evidence, was the reason the trial court granted summary judgment in this case for Altech. And if that's the case, it was the district's burden to show that that was error, that that evidentiary objection should not have been sustained, or that it was immaterial for some other reason. And the district never did that. In addition, it engaged in appellate waiver by waiting until its reply to raise the issue to begin with. To side with the district in this case on the waiver issue would set appellate procedure on its head. This court wants, and all appellate courts should want the issues to be developed fully in the briefs, each side having a chance to respond fairly, and that didn't happen here. The district waited until its reply to raise this issue that the evidence actually still was in the case when no one thought it was, including the trial judge. And it shouldn't be given that kind of flexibility in its briefing. It ought to raise those issues in its appellant's brief so that everyone has a fair chance to show why that's error, and it didn't do that. It waited. We raised these issues on the rehearing, but the Court of Appeals decided otherwise.
Well, we review summary judgments de novo, and so isn't there an element of if the Court of Appeals improperly concluded that the objections were not preserved, don't we then have to look to see whether that improper conclusion made any difference in the ruling? In other words, whether the Court of Appeals, in ultimately considering the report, whether that created any harmful error.
You would have to look at harmful error if you get past the waiver issues, right? So the appellant's first burden is you have to discharge and show it was error to begin with. And if you don't attack a summary judgment, that's well established in this court's precedents. If you don't attack a summary judgment on evidentiary grounds, so for example, an expert's opinion is excluded, and you appeal the grant of summary judgment, but you don't also attack the exclusion of the expert affidavit. Failure to attack that ruling on the summary judgment evidence waives the appeal of the challenge to the summary judgment itself. So it's not necessarily a question of de novo review as much as it is appellate procedure. When you want to attack a successful summary judgment, you must attack all grounds on which it was based. If the expert affidavit is excluded and you only attack the legal grounds without attacking the exclusion of the expert evidence, you have waived your attack on the summary judgment order itself. That's what happened here. Because they didn't raise it in their appellant's brief and show that the trial court erred in excluding the unauthenticated evidence, the Court of Appeals should never have reached the issue to begin with. And again, when they waited until their reply. So if it's under Rule 33.1, the court should have looked at the reporter's record, should have concluded that the evidence was excluded. That should have put the burden on the district to show that somehow the trial court committed error, and it didn't do that. But even if you get to the merits, Altech's objections, I would refer to the court to Altech's briefing. That wasn't so much our issue. It adequately briefed and showed why even attaching Kunkel's report, Mr. Kunkel's report doesn't really mention any specific value. It doesn't necessarily even attack the warranty that the Court of Appeals sort of funneled the district's case for them. It said, we're going to look at just this one warranty issue. It doesn't necessarily attack or show evidence of that conclusively. So whether it's unauthenticated, authenticated, even if it's attached to Altech's summary judgment, it doesn't necessarily go to the issues that Altech's identified in its brief. And now I would refer the court to those briefs. But so whether the court wants to decide this case on the basis of appellate error under 43.3 or 47.1, or it wants to decide the case on the grounds that the vacating Altech's summary judgment order itself was error, either way, the Court of Appeals judgment must be reversed.
I assume your client's preference would be to decide the case on the 33.1 issue, because that would mean there would be no remand to the Court of Appeals to address your rendition points and therefore no additional expense for your client. Is that right, or help me with that?
I think we get there either way, under either avenue. If the court agrees with us that 43.3 required the court to resolve the rendition points, we're in the same boat. We think that the rendition points will be decided in our favor, again, for reasons suggested by the Seventh Court of Appeals already. So we're fine either way. I think preference would be for this court to reach the 33.1 issue, because we've created this vast incongruity now between preservation and exclusion, this strange world where you can preserve objections without a writing, but somehow you can't have evidence excluded without one. And that seems entirely incongruent and now we've got to engage in this counterfactual analysis of, what would the trial court have done with a record it never considered?
But it seems to me that if we agree with you on that part, then would you not agree that we need to remand on the other issue having to do with the Fieldturf?
Yes, the court, in any event, the court will need to remand. Whichever path the court chooses to vacate the Court of Appeals judgment, it will need a remand for the Court of Appeals to resolve the rendition points, no matter what path it chooses. I think the cleanest way is for the court to take the path of concluding that the court committed legal error in refusing to consider the reporter's record and the excluded evidence there. That will clear up a conflict that now exists between the courts of appeals, the Seventh, the court in Amarillo and El Paso on the one hand, and now Texarkana on the other. So it's important certainly to the state's jurisprudence for that to happen.
But even if we do that, let's say if we find that the other issue about whether you all created a fact issue is not been resolved, then remand for that also. So
the fact issue isn't necessarily with our summary judgment. The Court of Appeals affirmed the trial court's partial grant of summary judgment for Fieldturf on the fraud claim. There's been no cross petition on that, so that is the rule of the law of the case. That's a dead claim. On a remand for us, all that's left to be decided for Fieldturf is the 5 rendition points. For Altech, I don't think the court needs to remand for consideration of anything other than I think this court should reach the waiver question, and that's the cleanest way to decide this, which is Court of Appeals, you were wrong about the reporter's record and the objections. The district waived by not attacking those evidentiary findings and waived by...
Does the Court of Appeals have some discretion to consider arguments raised in a reply brief?
It certainly does.
And in this case, did the Court of Appeals exercise that discretion and consider those arguments?
I see I'm almost out of time, Mr. Chief Justice. May I
You may
respond?
answer the question.
The court may have discretion in certain instances. Whether the court exercised that discretion or not is unknown because it never, in its order resolving the motion for rehearing where we first let the court know that this waiver issue was out there, it ought to have picked it up on its own, but it didn't. I guess the court might have discretion. All I would say is that's only on the reply issue. It still doesn't change the initial threshold waiver, which is the failure to challenge the trial court's evidentiary findings. If you don't challenge those at the outset, you've waived the attack on the summary judgment in toto. So I don't think there's much discretion on that. That's black letter law and has been in the state for some time. We ask the court to reverse. Thank you.
Any other questions? Thank you, Mr. Bennett. We'll hear from the respondent.
May it please the court, Mr. McBride will present argument for the respondent.
Good morning, Mr. Chief Justice. Good morning, Your Honors. Before I begin, I want to apologize a little bit about my voice, which may give out on me here because I'm having a terrible allergy attack this morning. This is a very strange petition, or pair of petitions, actually, because there's a lot of procedural oddities going on here, including the fact that lurking behind all of this is a significant disagreement between Fieldturf and a couple of school districts about how UCC remedies work as they relate to a refusal to honor a repair and replacement warranty. That's most of the render points he's talking about. Those are the points that he's talking about that are the same as the ones in the New Braunfels Independent School District case that I also have briefed against Fieldturf. We did get an opinion on that a couple of weeks ago that was unfavorable to us, but I believe it's mistaken, and I'll be filing a motion, or I'll be filing a petition for review shortly on that case, which will bring the real issue here in front of the court, which I think the court will actually find pretty interesting. So what we're here about is not necessarily that, because nobody's briefed that in this case, in either of these petitions. What we're here about are two discrete and unusual procedural issues that don't come up very often. The first that I want to deal with is the issue of remanding in the interest of justice by the Court of Appeals. And I'll be the first to concede I don't have a lot to say in defense of that. I was a little surprised, frankly, that they didn't address any of those other legal issues that we had, because we briefed them as well. Mr. Bennett talks like it's just a lay down render, but I think there's a substantial disagreement and a lot of unclarity in the law as it relates to how monetary remedies work under the UCC when a repair and replacement warranty isn't honored. And we briefed that as well, and we kind of wanted guidance on it as well. I mean, the problem is we go back on a remand and we run the risk of not being allowed to submit our jury charge again. Because the reason we appealed this is we didn't get the damages model we asked for. So that's why we were the appellants primarily, and then there were a couple of side issues as well.
It would
So-
seem that the district would also benefit from resolution of the legal issues.
I agree.
When you consider the expense of another trial for the district.
I don't disagree. I mean, I opposed the petition just because my version of that briefing asked for a remand, and I've got a remand right now. But here we are. If you want me to explain whether I think it's more prudent to have done it, no, I don't really have a good explanation for that. I could speculate about it, but it doesn't make a lot of sense. They probably should have dealt with it. So what that leaves then is the issue of this evidentiary matter. And Mr. Bennett presents this as though everyone agrees that the sole reason for the granting of that MSJ was the sustaining of the objection. No, everyone does not agree that. There's nothing in writing suggesting that the basis of the summary judgment was a fact. He uses the word factual finding. There's no factual finding in this summary judgment. It is the bare bones, the summary judgment is granted order that we see all the time. There's nothing implicit in here suggesting that he's making factual findings that are only consistent with sustaining the objections, and there's no written order on those objections. So let's drop back into the background here for a little bit and talk about what this summary judgment order was about. Altech was primarily concerned with the idea of being held liable for the defective fiber that Fieldturf sold and Fieldturf's refusal to fix it once it started to fail prematurely. And their argument was, and I don't disagree with them, which is why I didn't use it in our appeal of that issue, was that as to the contractor's warranty, the general warranty that the field would be free from defects, they're bound to install whatever the architects in the district had chosen as their material. Okay, fair enough. But separate and apart from the contractor's warranty, Altech had made a specific performance specification promise under this GMAX testing. And the gist of this is they are bounce tests where where a method is used to determine how much of the energy of something striking that field surface is absorbed by the field substance, which is these polyfibers supported by like a rubber grit called infill. And that's kind of the meat and potatoes of the issue here, because if that doesn't absorb enough force, then we end up with student athletes getting severely injured playing on these fields. So it's a big deal that it doesn't pass a GMAX test, and it's an important promise to say that it will comply with the requirements of industry-specific GMAX.
But what is your
testing
response
results.
to the waiver argument on that issue?
I'm sorry, I
The
didn't.
waiver argument on that issue, what's your
Okay,
response
so
to that?
yeah, let me get to that right now. As an appellate lawyer, we look at the record on a summary judgment appeal, and this part of this case is a summary judgment appeal. And you look to see what evidence was on the record, and the rule has been always, and even in this court's opinion, all right to the Syme case, I think I'm pronouncing that right, in 2018, the rule has been that summary judgment proceedings are supposed to be done entirely on the papers, and that includes getting a written order, either sustaining or overruling an objection to summary judgment evidence. If you're going to use objections as part of your summary judgment argument as the movement.
But your view is that a reporter's record, which reduces an oral ruling to writing, is insufficient indicia of the trial court's decision on an objection that's been interposed to the summary judgment evidence.
My position is that if somebody makes a reporter's record of a summary judgment hearing, and the court is now going to treat those as a written ruling on a summary judgment order, then you are opening a huge can of worms in appellate practice and summary judgment practice in Texas, because every appellate lawyer that I know is going to ask for a reporter's record from now on a summary judgment record and tell their trial lawyers that they're working with to get one. And they're all going to ask for a reporter's record.
Lawyers frequently ask for a record in a summary judgment case where they want rulings on objections. So, Your Honor, we need a record for objections to our summary judgment evidence.
No, we submit a written order and
But
asking
it
for.
hasn't the rule always been that you don't have to have a court reporter's record based upon the fact that you simply need summary judgment evidence, but you can have it. I know I was a trial judge for years, and I always did that.
Well, I think the appellate rule has been that it's supposed to be done without a reporter's record. Going back to McConnell, the whole point of McConnell was that the idea behind a summary judgment proceeding was that it was to be done without the need for a reporter's record and a transcript.
Without the need. I think
Yeah.
that's the...
Right, so then the problem becomes you're always going to have a reporter's record, because you don't know what's in there. So now you've
But
made
you don't
reporter's
need to
records
know
part of the
what's-
summary
You don't
judgment.
need to know what's in there if all of the objections have been ruled on in a written order.
I'm sorry, I didn't.
If there's a written order that's specific as to the rulings on the objections, then you wouldn't need to know what's in the reporter's
Exactly,
record.
which is the ordinary procedure as it's always
Right.
been my 23 years practicing
Right.
law in Texas. So you submit a written order.
So in a case like that, you wouldn't need the reporter's record.
You wouldn't need the reporter's record, right? But you
So how are we opening a can of worms?
well, because now you're going to have the reporter's record be part of the summary judgment record on appeal.
Not
So
if
it's gonna
there's
be-
nothing relevant in there that's not also in the order.
But nobody knows that until, like, if an appellate lawyer that's just coming fresh onto the file isn't going to know that. They're not going to know that there isn't anything that's important to their appeal in there.
Well,
So-
they might if they talk to their trial counsel.
Well, but the trial lawyer, sometimes they know, sometimes they don't. And looking at it through the eyes of an appellate lawyer with the procedure in mind for what that, for how that process works on appeal, you see it a little differently maybe than the trial court, or than the trial lawyer did.
Well, presumably you would see the written objections in the record, and you could match that up with the order and tell were they all ruled on or not. And if not, then maybe you want to look at the record of the hearing.
You could, I think if the court's certainly your prerogative to expand to treat reporters' records as written orders going forward. I think you are going to see that a regular practice of then ordering reporters' records. Because
I guess my question to that is, what is the problem with that? It may be that you needed it, you didn't need it, and so in an abundance of caution, you're always going to ask the reporter to come in and make a record, but
there's no like injustice to it other than it's change in procedure that's going to increase the expense and delay. It's just that much more that has to be prepared on a summary judgment appeal in order to have the record prepared. You have to have a reporter's record now that you have to order and pay for and
the
wait
transcript
to arrive.
yeah.
Which was the
Only if
point.
there are evidentiary issues, though, right? Because you would still have to have a written order on the summary judgment. We're just talking about evidentiary.
Exactly.
rulings.
Yep, that's correct. Yeah. And so in Seam, the court reiterated the same rule. It has to be a written order, but opened it up to the possibility that the summary judgment could have an implicit ruling. But
In
this
that
summary
case,
judgment
wasn't
doesn't
it
have
more
that.
that there was nothing to show an implied ruling on the objections because there was no indicia one way or another how the trial judge, whether the trial judge considered the objections and made a ruling. And so is this case different in that we have a ruling from the trial judge in the record before us?
I think I think it's a little different in that sense, but it still goes back to the issue of whether or not that reporter's record is a writing for purposes of a summary judgment appeal. Let me address it.
Okay, I'm just not quite following what you're saying. So if the reporter's record is a writing for purposes of appeal, then you're saying that's the factor that means that the court's ruling, even though it was clear from the rendition, had to be in writing?
No, you could do it three ways. A trial court could do it three ways. Well, two ways and possibly three. The third one I disagree with. I think it's not something we should do or that we have required prior to this case. You can have a written order on the objections themselves, sustained or denied. That can be part expressly. That can be part of the summary judgment order, or it could be a separate order. I often do them as a separate order. I see that all the time. Second way is you have some kind of factual finding or statement in the summary judgment order that implicitly indicates that the trial court didn't consider that evidence. And then the third way, which is what we're here about today, would be having a reporter take down the events of the hearing and then ordering the reporter's record and then turning it into a writing for purposes of the appeal after the fact. So that we are now making reporter's records part of the summary judgment appeal process. I would say there's a couple things that I wanted to tack on this issue. Number one is I don't think that's clearly been the rule in the state, that a reporter's record is part of a summary judgment record on appeal. They're almost never ordered when either at the trial court or when the record is prepared for a summary judgment review. If that's going to be a way to have a written order, I think there's enough lack of clarity in the law about whether or not that's a written order on objections when summary judgments are supposed to be done without a reporter's record, that if you're going to remand for determination of the other points, that legal disagreement that we have about some of these issues, then send it back down and I'll be happy to brief it on the merits as an opening point again. In the interest of justice, I think that would be the appropriate remedy. Secondarily, I think the Court of Appeals does have the discretion to consider things that are raised in a reply brief. So I didn't raise it because I didn't see a written order saying that it had been sustained. So when they brought it up in their responsive brief in the Court of Appeals, that's when I brought up that they hadn't gotten a written order. So that's the first time we got into that. And I think the Court of Appeals can consider that, and they did, obviously, because that's the basis of their opinion in this case. So I don't think it was waived. And I don't think that it was completely unauthenticated to the point that it wasn't evidence, because the other issue that's going on here is there are there is evidence showing that this is what it purports to be. Not only the deposition excerpts that were attached from Mr. Kunkel to the district's summary judgment response, but that report is referenced in Mr. Kunkel's report that Altech attached to its own motion for summary judgment. So it specifically identifies a Bounce Logistics GMAX testing report done in March 2016. Those are distinct attributes, characteristics of that report, which is the report that we attached to our summary judgment. It's mentioned both by Mr. Kunkel and discussed in there, and it's mentioned in his report, which was attached by Altech, not us. So there's a lot of corroborating evidence that March 2016 GMAX testing report that's in the record is exactly what we purport it to be, which is the rule under 901. Is it the ideal way to prove it up? No, you could do an affidavit. I mean, I didn't do this one, but you would normally, the best way is to do an affidavit where he identifies the document, or you do the next 2 pages of the deposition transcript where he mentions that that's a true and correct copy and it becomes a deposition excerpt or exhibit. But, that's not the only way to do it. Under, it's 901B1. It can be authenticated by circumstances such as identifying the document by its distinct characteristics, which there's enough on the record here to have done that. And in the Fleming case, the court held that you can have circumstantial evidence to authenticate a document under 901B1.
I can take you back to the written order requirement issue. I'm kind of sympathetic to your real-world argument. I can remember trial judges that would not allow a court reporter at a summary judgment hearing. But one of the parties would ask for it, and the judge said, no, I sent my court reporter to lunch because you told me this was a summary judgment hearing. We don't need a record.
I've heard numerous trial courts say that.
I've seen that happen. And when that happens, the parties know, look, if you're going to object to the other side's summary judgment evidence, that has to be a written objection. And if you want a ruling on that objection, you need to get a written order ruling on it. You just know that. There's no reporter's record. But if there is a reporter's record, is it your position that the objection still has to be a separate written document, or does a objection asserted orally in open court that is recorded into the reporter's record, does that suffice to preserve the objection?
I think there needs to be a written order that indicates either explicitly or implicitly what the trial court did or did not consider.
So there doesn't have to be, in your view, to preserve the objection, there doesn't have to even be an objection made orally in open court?
No, there should, but there does need to be some writing indicating what the trial court considered to be part of the record it was reviewing.
So in order to preserve an objection to summary judgment evidence, the party doesn't have to file a written objection or raise an objection
Let me step back for a second.
on the record?
It depends on whether or not they are appealing if the objection was overruled or sustained. I think if it's sustained and it's in writing that it was sustained in some form or another, explicitly or implicitly, so that it's clear that the trial court sustained an objection and didn't have that, and that evidence was not on the record when the summary judgment was rendered, yes. If it's overruled and one of your arguments in response to an appeal challenging that summary judgment is that the trial court erroneously overruled your objection, then you need to get a written order on there has to be something written showing what the objection was that was
And would the
overruled.
reporter's record suffice to show that you preserve that objection by raising it orally in open court?
No, I think you'd still have the same problem, which is then
Because that's your opposing counsel's argument is that it's incongruent to say that a objection raised in open court on the record would preserve the objection, but that the ruling on that objection in open court on the record is insufficient. And so what I think I hear you saying is neither one's sufficient.
Well, my argument is that you have to. There is no reporter's record on a summary judgment review. That's my argument. And so whatever you're going to be able to determine did or did not happen, it needs to be determined based on what's in the clerk's record. That is in a nutshell my argument. We're supposed to just get a clerk's record on these summary judgment reviews. And if you need something to be documented on the record, you put it in writing if it's a summary judgment hearing.
So if somebody moves for a continuance of a summary judgment hearing and it's denied on the record, but not in a written order, then that's not preserved?
Yeah, I think, so I had that in a recent case, and I think the case law on that is that the continuance is itself not the summary judgment hearing. So yes, you could have a reporter's record as it relates to a continuance, a motion for continuance, which is a different motion.
Because you need a ruling on that if you're going to come up and say, I didn't have enough time to do discovery and that's what.
Yeah, so in those circumstances, you would get a reporter's record because there's another motion involved that does involve a reporter's record. That's my recollection. And actually, I need to go back and look. That's my recollection. I had that issue in a case recently where there was a reporter's record ordered specifically for the purpose of a continuance of a summary judgment hearing. Last thing I would say is that Mr. Bennett said that the evidence that Altech itself attached, which is our expert's report talking about the failure to meet the GMAX testing, didn't conclusively establish that they failed to meet it. Well, it's a summary judgment and we're the non-movement. We didn't have to conclusively establish that it didn't meet the promised performance standard. We just had to raise the genuine issue of material fact. And we don't have to even introduce any evidence if they put on evidence in their own motion that supports that. And that's really the crux of what happened here. To go back to an issue I was talking about at the beginning.
What is your response to his argument that that did not raise a fact issue?
My response to that is that in their own evidence, because we're specifically talking about whether it failed the GMAX test.
I understand.
In their own evidence, there is a statement from our expert in his report that it failed the GMAX test. And specifically references the Bounce Diagnostics report from March 2016.
Report,
yeah.
You're talking about? Yeah.
Yeah. So I think what they did was they weren't focused on that warranty at all. They were solely focused in their motion on not being held liable for Fieldturf's refusal to do the repairs. And so they just put our own expert's affidavit in there, proving up what was really the warranty claim against them, which is the failure to meet the specifications of in the testing.
Any other questions? Thank you, Mr. McBride.
Thank you.
Mr. Bennett, you have 5 minutes.
Thank you, Your Honor. A few points on rebuttal. I want to start where he left off. We have to remember the way the case flowed as reflected in the record when it comes to Altech and its claim and its arguments on summary judgment. The principal thrust, the reason Altech attached Kunkel's report to its summary judgment motion was because the district at that time in April of 2018 had not made this GMAX warranty claim. It was focused on the fact that its contention was Altech was somehow responsible for Fieldturf's product for which it had issued a separate warranty. That was against the contractual language in the record. The Court of Appeals recognized that in its decision and said the district hasn't challenged that aspect of the trial court's ruling in summary judgment. What came up after the fact, in like the 5th amended petition or something, was this GMAX warranty. The Kunkel report shows this latent defect problem, which runs counter to the contractual language that Altech and the district had agreed upon. And this GMAX issue was a sideshow raised at the last minute to try and preserve a claim against Altech that probably shouldn't have been preserved. The district then argued in its response to summary judgment that the Kunkel report, and then attached it itself, somehow shows that it failed the GMAX test. And the Altech then argued, look, it's not authenticated as they're trying to assert it offensively in my brief or in theirs. The idea that the GMAX wasn't the basis, the exclusion of the GMAX wasn't the basis for the summary judgment, runs counter to the record. If you look at 4 Reporters' record, page 36, it's the exact holding of the trial court. The only evidence to keep the GMAX claim alive was Kunkel's report about the GMAX results. If the GMAX test and the GMAX testimony unauthenticated as it was is excluded, there is no evidence to support that claim.
But we do have cases that we don't look to the reporter's record for the trial court's reasons for granting summary judgment, right? You just look to the order.
Correct. However, when it comes to a ruling on summary judgment evidence, we can marry the written order and the evidentiary objections and reach the conclusion that if the only evidence to support, to contradict or defeat the summary judgment motion is the GMAX test, and it's unequivocally, patently been excluded by the trial court in the reporter's record, there's no other basis to for ruling as the trial court did on that issue and the others. The district didn't appeal the others. It appealed only the GMAX warranty. And this gets to the main thrust of the defense that the court needs to embrace, and that's do not let appellants wait until a reply brief to raise an issue they ought to have raised in the first instance. And
But
that
his
is
response to that is, I didn't know to raise it in the first instance because there wasn't a ruling on that objection in the order or in writing anywhere. Why isn't that a good response and a good reason that the Court of Appeals could have considered in deciding to consider the issue as it was raised in the response and the reply?
So this brings up the real-world implications that my friend on the other side has raised. This was a multi-purpose hearing. This was not a summary judgment hearing only. This was a pretrial hearing. Front page of 4 Reporters Record, Volume 4, shows that. There were several issues here: exclusion of experts, our own summary judgment effort, yes, other summary judgment objections that we made to affidavits and other things, as well as other pretrial rulings. And I think that sort of exposes the real-world problem with what my friend on the other side is advocating in this incongruency between preservation on the one hand and effectuating the exclusion of evidence on the other. And that's in a hearing like this, where it's sort of a mixed bag, that's right before trial, where all of these motions are being resolved, and that is exceedingly common in our trial courts, given their caseloads and just their discretion to manage their own dockets. In this kind of case, that's exactly why the court, on the one hand, doesn't require a special written order for preservation. And there's no principled reason to require that in going the other way, that no evidence is excluded unless there's a written order effectuating that exclusion. If you look at the summary judgment order that the trial court entered for Altech, I think it's tab 3 or 4 to our brief on the merits, there's no mention of the evidence. The court just says, having considered the arguments, the briefs, summary judgment is granted.
Is that your answer to the question that has to do with, it is true that in most trial courts, I believe, when it's only summary judgment motion, that there is no record. But sometimes there is a record, and someone asks for a record, and there's a good reason, and so the trial court will grant that. And if that's in fact what happens, then it changes the rules in terms of what needs to be in writing. And your answer to that is what you just answered to Justice Busby, is that right?
Correct. If there's no appellate record, no record of the summary judgment hearing, obviously you will need a written order in that case.
It's in terms of a reporter's record. Yes.
Correct. But in where there is a reporter's record, I think it's formalistic to the extreme to tell a court of review, you cannot look at what the trial court clearly said and the conclusions it clearly reached on the face of the record just because, well, that's just summary judgment practice. That isn't summary judgment practice. There's no rule that compels that conclusion, whether it's 166A or rule of appellate, it's Texas Rule of Civil Procedure 166A or Rule 33.1 of appellate procedure. There's no textual basis for that kind of conclusion, and in practice, it just won't work. It won't serve parties well. It won't serve courts well. So the best answer for the best way to resolve this case is to conclude the Court of Appeals initially erred in concluding that the evidence, that the oral rulings on the record didn't effectuate exclusion of evidence, and that the district waived its attack on the summary judgment to begin with at the threshold issue because it never raised it in its brief. For all of these reasons, the Court of Appeals judgment should be reversed. The case should be remanded to consider Fieldturf's 5 rendition points and to affirm Altech's summary judgment. Thank you.
Any other questions? Thank you, Mr. Bennett. The case is submitted. That concludes the argument set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.